So friends, Donald Trump's lawyers met with Special Counsel Jack Smith, trying to talk him out of indicting their client. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, as we remain on Trump indictment watch, there was an important development today. Donald Trump's criminal defense attorneys met with Special Counsel Jack Smith and his team to try to talk them out of indicting Donald Trump for his crimes. Here is the new reporting from the Washington Post. Headline: Trump lawyers ask Justice Department not to charge Trump in classified documents case. And that article begins, attorneys for Donald Trump went to the Justice Department on Monday morning to make their case that the government should not charge the former president in connection with his possession of classified documents after leaving office, according to people familiar with the matter. Trump lawyers Lindsay Halligan, John Rowley, and James Trusty spent about 2 hours at the Justice Department and left without speaking to reporters. They met with Justice Department personnel, including Special Counsel Jack Smith and a senior career official, but not Attorney General Merrick Garland or Deputy Attorney General Lisa Monaco, said people familiar with the matter who, like others interviewed for this article, spoke on the condition of anonymity to discuss a closed-door proceeding. The Justice Department declined to comment. While it's not uncommon in high-profile cases for defense lawyers to get such a meeting with Justice Department officials toward the end of an investigation, current and former officials say such presentations rarely change prosecutors' minds. Two Trump advisors briefed on Monday's meeting said they continue to believe Smith will finalize a charging decision in the coming weeks. The advisors said they are preparing for a potential indictment of the former president, and the meeting did not change their expectations. So the reporting about this meeting conjures up a number of questions. Question number one, is this normal operating procedure? And the answer is sort of. In large-scale, white-collar crime type cases, when the prosecutors are investigating overtly, in other words, out in the open, they're subpoenaing lots of people, it's no secret that an investigation is being conducted. It's probably no secret who the target or targets of the investigation are. So when it's an overt investigation out in the open, it's not at all unusual to invite in the defense attorneys who are representing the target of the investigation to make a presentation. I'll talk more about what that presentation usually involves in a minute. But let's contrast that to when prosecutors are running covert operations, covert investigations, including in the grand jury. You know, sometimes we, and I'm a former career prosecutor, we would run investigations covertly. We would be quietly and secretly investigating crime because we didn't want to tip off the target of the investigation that we were running a grand jury investigation into a crime or into a conspiracy, into a criminal organization. Because if you tipped off the bad guy or the bad guys, they may flee, they may destroy evidence, they may intimidate witnesses. So sometimes we will investigate covertly, we will quietly indict, then we'll get an arrest warrant. And the first thing anybody knows about an investigation is when the FBI comes banging on someone's door at 6 a.m., executing a search warrant, arresting them so they can be presented in court and arraigned on the indictment. Obviously, in covert investigations, the prosecutors aren't going to reach out to whoever it might be that's representing the target of that kind of an investigation and say, come on in, because we think we may be indicting your client sometime soon. But in overt investigations, like the investigation of Donald Trump's classified documents crimes, where everybody knows he's being investigated, heck, everybody around Donald Trump has been subpoenaed, his own attorneys have testified against him in the grand jury, it's not unusual to have a meeting like this. So what does this meeting involve? What does it look like? I've participated in these meetings, and I'm going to talk about one specifically in a few minutes. So generally what happens at these meetings is the prosecutors are there to listen. Listen to what the criminal defense attorneys have to offer by way of exculpatory evidence, evidence that might show that their client didn't commit any crimes. Sometimes defense attorneys have a smattering of exculpatory evidence, evidence that might be helpful to the defendant's cause. We listen, we take that evidence, we assess it. They might also offer precedent, that is some sort of case law, some sort of appellate court opinions that relate to the charges that we're thinking about bringing, to the charges that we think are supported by the evidence. Maybe the defense attorneys have some legal arguments they want to make. We listen. Sometimes they will make policy arguments, and that's what I have a feeling Donald Trump's lawyers spent a lot of time doing when they met with Jack Smith and his team. They probably made policy arguments like, we need to heal the nation. We need to put all this ugliness behind us. America needs to move past Donald Trump. So we think you should give him a pass for the crimes you believe he committed. To which I would respond, you know what? We tried that in 1974 with Richard Nixon. Didn't turn out so good. In fact, I have contended all along, friends, that you can draw a straight line from Richard Nixon being given a pass for his crimes to Donald Trump and his lawlessness while in office and after he left office, probably thinking he could do it all with impunity, get away with it, just like Richard Nixon did. You know what, friends? In my 30 years as a prosecutor, I never once looked at a victim and said, you know how I think you can best heal? You know how you can move past what happened to you, what was done to you? It's if I decline to prosecute your attacker, your perpetrator. That's how you're going to heal. That is the opposite of justice. That, friends, is a perversion of justice. That's what we did with Richard Nixon, and I don't believe for a minute that's what Jack Smith or Merrick Garland will do with Donald Trump. But I suspect Donald Trump's attorneys made the we have to heal the nation argument, so let's just give Donald Trump a pass. So that's question number 2. What goes on in these meetings? That's sort of what goes on. Question number 3. Does any of this ever persuade a prosecutor to change his or her or their minds? Not in my experience. I guess it's not impossible. Perhaps a prosecutor has changed their mind after a defense presentation. I never did in the cases that I was involved in that had meetings like this. And then the last question I want to take on is one that I've heard asked repeatedly over the course of the last 24 hours or so. People are asking, and I think people are rightly concerned, could this be a plea bargaining session? Could they be talking about possible pleas to resolve the case against Donald Trump? Like maybe Donald Trump would offer to plead guilty and promise not to run for office. Or maybe Donald Trump would offer to plead guilty if they would agree to a sentence of probation, no prison time. Or maybe Donald Trump would offer to plead guilty, and to sweeten the pot, Donald Trump would say, you know what, I'll give you back the rest of the classified documents that I'm still unlawfully concealing from the federal government, because I'm quite sure he is. That would be like a offer to plead guilty with a smattering of extortion, holding the classified documents hostage in exchange for a sweetheart plea. So here's how I can best answer the question, might this have been a plea bargaining session, or might pleas have been discussed? The answer is, I don't think that's the purpose of these meetings. However, I was in one of these meetings in a death-eligible case, a case where the authorized punishment for the crimes that the defendant or the target of the investigation had committed included a possible death sentence, a death-eligible case. And we were not there to talk about possible pleas. We were there to listen to whatever the defense had to present as we were trying to make the decision whether to indict death-eligible charges. And the defense attorney just sort of threw on the table a plea offer. Well, my client is offering to plead guilty if, and then they proposed a certain sentence. So it was a meeting that was not intended or designed to be a meeting about possible guilty pleas or plea negotiations, but the defense attorney did throw a plea offer on the table and offer to plead guilty. Now, I will say that did not cause the meeting to morph into a discussion of guilty pleas or plea negotiations. We listened to what the defense team, the defense attorneys had to say, and we thanked them for their time and the information they provided, and then we took a step back and assessed. But I would say that these meetings are not designed to be plea bargain meetings, but you can't rule out that somehow, some way, pleas may have been discussed. I also do not happen to believe that this case will be resolved with a guilty plea. I don't think Donald Trump has it in him to plead guilty and accept responsibility for his crimes. Maybe I'm wrong about that, we'll see. But I think this case will be indicted, and I think this case will go to trial. And once in trial, the evidence is extremely strong, in part because people may not know that every incriminating statement Donald Trump has made is admissible as evidence against him. It's a statement of a party opponent. But every exculpatory thing Donald Trump has said, I had every right to do it. I believed I had a right to do it. I believed they were declassified. The defense attorneys for Donald Trump are prohibited from introducing any of those statements of their client. So the rules of evidence are a one-sided proposition when it comes to statements of a defendant. The prosecution can introduce any and all incriminating statements, but the defense can introduce no exculpatory statements unless Donald Trump testifies. And I don't think there is a prosecutor alive who wouldn't give their right arm to cross-examine Donald Trump. I know I would. So let me finish with this. I doubt Jack Smith and his team were moved away from their conclusion that Donald Trump must be and will be indicted for their crimes. Based on the evidence, I have to believe that's the decision they have reached. I believe Merrick Garland will accept that recommendation from Jack Smith. I believe Donald Trump will be indicted. I believe he will be prosecuted. I believe he will be convicted. And I also happen to believe he will end up in prison. We'll talk about why I feel that way in future videos, but I do believe he will be punished for his crimes against the United States and we the people. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again soon.